Are you well?
I'm keeping well. I almost halfway. I meant to say good morning, Chief Justice, President of the SCA, Minister, and the Honorable Commissioners.
Yes. Are you relaxed or should I assist in that area?
I would appreciate if I were to be assisted in that area. This
Yes.
is not an easy platform.
Yes. You started off as an interpreter in a magistrate's court, is that correct?
That is correct.
At Mutu.
Yes.
And for how many years were you an interpreter?
It was a question of months because I already had a legal qualification, and then I got appointed as a prosecutor.
And you became a prosecutor. I see that it's in 1980, but for how long did you serve as a prosecutor?
I would imagine it was 1 or 2 years. It was not long.
Okay, and then you went to serve articles.
Yes, I first had an opportunity of being awarded a bursary that I thought I would not get, which I used to finish my LLB, and thereafter I had to go and serve articles. I had to resign from the Department of Justice.
Yes, and yes. I hope I didn't interrupt you.
No, you did not.
Okay. And who did you serve your articles with?
I served my articles with a firm known as George Hutton and Company in Fred, in Northern Natal.
In Fred.
Yes.
Yes. And then you became an attorney. Were you alone in your firm of attorneys? It was actually a company, isn't it? Dlodlo and Company. Were you the only director there, or were there other directors?
I was the only director with some professional assistants, and before that, which may be not appearing on my CV, before I went on my own, I became a professional assistant in the same firm in which I qualified as an attorney.
Was the legal profession as lucrative as it is now, or not yet?
At the time, it was lucrative because money was not really, had not lost value, and the little that the members of the public paid us, we were able to make ends meet.
Yes. And you then ultimately acted as a judge of the High Court.
It's correct.
Where was that?
I acted as a judge of the High Court in the Western Cape. It was now then known as the Cape of Good Hope Provincial Division.
Yes. And when was that?
I started there in 2003.
Yes.
And subsequently became appointed in 2004.
Was it a continuous act instinct, or were there some breaks in between?
No, it was a continuous acting instinct. In fact, I started at the labor court in 2000.
Yes.
When I finished there, I got invited to the High Court.
Yes.
Where it was continuous there until appointment.
So you've been a High Court judge for a little over 14 years, isn't it?
Yes, it's true that I've become somewhat comfortable in that post. It has been many years of work there.
And you acted in the Labor Appeal Court as well?
Yes.
For altogether 4 terms?
Yes.
And for how many terms did you act as a judge of the Supreme Court of Appeal?
The Supreme Court of Appeal in 2016, I acted for 2 terms. And this year, the first term, I'm from there. We just finished on Friday.
Are you still there, or have you completed your acting stint for this year?
I've completed my acting stint for this year.
And for how many terms did you act in the Constitutional Court?
The Constitutional Court, I acted for 4 terms.
Yes.
In 2018.
Yes. And on a lighter note, why did you prefer the SCA over the Constitutional Court?
As Chief Justice, the Constitutional Court, as a matter of fact, is an apex court. I'm always a guy that does not think highly of himself. And I thought, in view of my experience at the High Court and the kind of work that I've been exposed to, that I've been doing over the years, I would be better able to contribute to the jurisprudence of the Supreme Court of Appeal, where in the event of any mistake, my mistake can still be addressed by way of the mechanic of appeal to the Constitutional Court. And in that way, the litigants will not suffer.
Yes. Well, as briefly as you can, but without compromising the quality of your statement, why would you say you're the right person for this position? Or one of these vacancies, at least?
Chief Justice, regard being here to the years that I have spent as a judge of the High Court and the kind of matters that we deal with at the High Court level, I've come to a realization upon acting at the Supreme Court of Appeal that I would be a right candidate there. The experience that I have picked up over so many years has grown me and has made me very much matured in the manner I approach each individual case.
Thank you. President Maya?
Thank you, Chief Justice. Good morning, Judge Dlodlo.
Good morning to you, President.
You are currently acting at the Supreme Court of Appeal for the second time now.
Yes, President.
How have you found your experience there?
I found the experience there to be rather rewarding, and I've been happy when I came back to act in the Supreme Court of Appeal this year. It was like coming back home. All the memories that I had in 2016 became fresh in my mind. I worked well. I know that the President was not there, but I really worked well. I did not experience a problem on my path, not at all.
Is there anything that you think the court could do to make acting judges more comfortable, or everything is all right in your book?
Yes, I have heard a lot from acting judges who are not treated properly by permanent judges in the same court. I come from a school of thought that says courtesy and collegiality towards a fellow judge or fellow judges are indispensable attributes of a judge. Yes, things need to be done differently in order to make acting judges feel very comfortable and that they be themselves. A person produces the best out of himself if he's relaxed and is not subject to unduly influence and undue criticism. Because if a person is made to look like a non-entity, that person loses his self-worth and the esteem, can easily make mistakes, even in respect of very simplistic matter. Having said that, I want to say these things that are experienced by acting judges in the Supreme Court of Appeal do need to be spoken about in various relevant fora, including this forum. And by speaking and addressing them strongly, they can come to an end. Every permanent judge, senior or junior, started by being an acting judge. So an acting judge is an entry point. If we discourage acting judges by virtue of the fact that they are new in the new surrounding, then we are totally refusing entry. having said that, I must hasten to say, I as an individual was very fortunate. In 2016, the 2 years that I spent at the Supreme Court of Appeal, I did not experience what fellow acting judges told me they experienced. And this year too, in the term that I have spent there, I also did not personally experience it. And maybe I'm very fortunate. But I'm still concerned because fellow acting judges feel they are treated badly. And in that way, they lose their self-worth. They lose the esteem. And it's not nice.
Do you struggle with judgment writing, and how have your draft judgments been received by your presiding colleagues?
I was fortunate that in 2016, in my very first judgment at the Supreme Court of Appeal, I happened to have been seated with the President putting questions to me. And when the judgment was conferenced, it was conferenced in a dignified manner, and suggestions were made which I accepted, and certain things that I would have stated in the judgment, reasons were given that I should state them differently, I accepted. And the other judgments that came to light on that particular acting incident of 2016, I must say, it worked out nicely for me. I don't know why, but I did not find the kind of criticism and the kind of concern and the crying which I hear reliably from the fellow judges. This year too, the judgment that I wrote and circulated, colleagues commented on the judgment, incorporated certain comments and not the others, and eventually at conference it passed. And I did not have the pain of having to explain this particular point is not properly decided, this particular point, what do you mean here? I'm saying in that regard, I'm fortunate because it's not happening to other judges.
Thank you, Chief Justice.
Thank you, President. Commissioner Singh?
Thank you very much, Chief Justice. Good day, Judge Dlodlo.
Good day to you, Mrs. Singh.
Firstly, I must say, Chief Justice, I'm very happy to be interacting with a gentleman whose naval cord is buried in Kwanongoma, because I'm very familiar with the territory of Kwanongoma and Abakulusi, which it is now called, Fried is now called Abakulusi. And I see the values of Hlonipa comes out very evident from the way Judge Dlodlo has answered those few questions. Thank you for that. What I'd like to know, Judge, is I just want to know what informed this great geographical transition from Vryheid to the Western Cape. How did it come about that you found yourself there as acting judge way back in 2002?
Through you, Mr. Chief Justice, Mrs. Singh, I was first and foremost, like I said in my outline, invited in the labor court. I was a private practitioner practicing in Vryheid. I was invited to act in the labor court, and when my acting instance finished in the labor court, went back to practice. A few months thereafter, I got a call and got invited to go and act at the Western Cape High Court. And that was a continuous acting instance there until I became interested in the geographical surrounding. When the post got advertised at the Western Cape, I did not hesitate to make my name, to forward my name and say, and raise my hand and say, I'm available. I want also to be part and parcel of this, should you consider me. And I went for the interview, and which was successful. And I got settled then in the Western Cape. But of course, as a man from the area that you have just mentioned, I can't lose my roots. Any opportunity, no matter how slight, I use and go back to my roots and drink the water of my place and look if the mountains and the rivers are still there.
No, thank you very much, Dlodlo. From yesterday and even today in discussions over tea and elsewhere, we've been hearing about alleged racism within the environment of the Supreme Court of Appeal. Have you any experience of that, because you've been acting there for a while, and how serious is it and what can be done to address it?
Through you, Mr. Chief Justice, I'm saying this, that I don't know what is wrong with me, because I'm not fortunate enough to experience this during the time that I spent there. I thought I was acceptable, but I know that colleagues are complaining a lot about it. So I would accept it exists, but it has not been directed towards me. Dan is Dan, and we just work. And they referred to me on my first name. I think they like the name Dan.
Yeah, just as a follow-up, Chief Justice, how will you contribute to getting the environment much more calmer at the Supreme Court of Appeal with your kind of experience? What intervention would you personally take?
A concerted effort needs to be engaged in. Killing and stamping out an evil called racism is not an easy one. We know for a fact that racism still shows its ugly nose, even in the community at large. It's still a challenge, but it will have to die in one way or the other. As an adult South African, if anybody practices racism towards me, I don't think I'm precluded from directly dealing with the situation, not violently, but talk as an adult that this is now not on. Please, let us be civil to each other as adults, South Africans. Eventually, the message will be driven home. We might find ourselves in a situation where we have a community, the South African community, not the racial components of South Africa that tend to fight.
Thank you, Chief Justice.
Thank you, Commissioner Singh. Commissioner Mpofu.
Good morning, Justice Dlodlo.
Good morning. I've almost said Advocate Mpofu.
Yes, yes, no, we are in a different arena. This time I'm the one asking you questions.
I agree. I think it must frequently so happen.
Thank you very much, Justice.
So I really do put some questions to you when you are in your capacity in court.
I know. Thank you, Justice. Justice, I'll ask you just one question. I always try to ask some of the uncomfortable questions that people might raise in harsh corners, but not here in this forum, to give you an opportunity to deal with it, more or less. And I'm going to ask you on the question of your age. You are the oldest of the applicants here, and in 2 days' time, it's going to be your 67th birthday. Now, some people might say that is a disadvantage. Others might say it's an advantage because you have obviously collected a wealth of experience. It's very clear from your application, and I must commend you for the level of diligence that is reflected from your application. But the question is this: bearing in mind that we are not dealing with a high court, but a court of appeal, where experience might be valuable. If, let's assume, I'll give you a hypothetical situation. If we have 5 vacancies, if we have 4 people, and we tick those 4, and the only remaining vacancy is now between you and, let's say, the youngest applicant. On what basis would you say in that situation we should go for experience and the obvious judicial pedigree that you carry over youth, assuming everything else is equal? In other words, as I think it was Dale Carnegie who said, when you have a lemon, how do you make lemonade? So if that was, should age be used as a disadvantage in this particular case, or should we go for experience, and on what basis? Thank you, Chief Justice. That's my only.
Thank you. I would say this, that a lemon which grows on a tree, you should not take it away when it is still too young. Allow it to have time to mature, then it will taste better. And the years that I have spent as a judge should not ordinarily, in my submission, be used as a disadvantage to my further advancement to a different level. I want to say to this House, through you, Mr. Chief Justice, I do not blame myself for having spent so much time at High Court. I have matured. And I want to say the Supreme Court of Appeal is a very important institution which should be occupied by matured people. And matured people are ordinarily not young people.
Thank you.
Thank you, Commissioner Mpofu. Commissioner Msomi?
Sorry, thanks, Chief Justice. Justice Dlodlo, there is a reference in the report that has been prepared for us about the cases that you presided upon. One was about the jamming that happened in Parliament, where a critique of your judgment is that you seemed to defer to Parliament and so on. So in light of that judgment, are you able to comment first on that criticism that you deferred to Parliament instead of making a firm decision? 2, are you able to comment on what I will call your judicial philosophy? Would you be able to pigeonhole yourself between conservatism and liberalism, judicial activism, vis-a-vis judicial restraint in your jurisprudential approach to adjudicating matters? Thank you.
Thank you. In that particular case, I know it is a broadcasting case where there was a jamming in Parliament. You would recall, through you, Mr. Chief Justice, that the minister concerned considered that this was not told to the Speaker nor to the chairperson of the NCOP. They were also taken by surprise. And the reason why I decided in the manner I did was that at that particular time, there was no guilty party. The whole thing had become moot to a certain extent. It was wrong that jamming takes place, but it had become moot in the sense. But I accept wholeheartedly what the SCA did. The SCA did not really criticize me. It merely said that things like this must never again be done without the knowledge of the Speaker. And I happened to have been acting at the SCA at the time that judgment came out. And I was surprised at the courtesy displayed towards me. In the morning before the judgment came out, the judgment writer came to my chamber and said, Dan, I'm going to deliver a judgment in terms of which I'm going to reverse your order in the High Court. I don't want you to get this thing from the press and from any other quarters. And that was delivered. I found that was courteous. I mean, the senior judge was not obliged to even inform me like that. The second leg of your question had to do with
judicial philosophy, Judge Dlodlo.
Simplistically speaking, when a matter gets presented before a judge, it's presented by way of either an application or an action matter, which is an action matter will necessitate that witnesses deliver oral testimony and they are subjected to cross-examination. And if it's an application, it will come, evidence will emanate from the affidavits, which would be founding affidavit, answering affidavit, replying affidavit, and possibly also supplementary affidavit. I use this evidence in my judicial philosophy and apply this to the factual scenario and apply the law. And in that way, I come to the conclusion that justice dictates that I take this particular path. It directs me. Yes, sometimes I can be wrong because law is complex. It's easy to make a mistake, but I take my time. I even dream about my work at night and jump. If I find a point, I jump and note it immediately. Sometimes my wife thinks I'm not right in my head. And our profession is good in the following sense that built into it are the checks and balances by way of reviews and appeals. Should Dlodlo make a mistake which will prejudice a particular litigant, that litigant can either take the matter on review or appeal to a better court, and Dlodlo, if he's wrong, he will be corrected and justice will be allowed to prevail again. It is not easy. It's not an easy matter. Law is not easy. It's not meant to be easy because it varies from one case to the other.
Commissioner Norman.
Thank you, Chief Justice. Good morning, Judge Dlodlo.
Good morning to you, ma'am.
Good morning. In one of your judgments, which unfortunately I could not locate a copy of, the S versus Solomon's judgment, you refer to it. And there you make reference that you applied in that judgment the ukuteza custom. Could you just explain to the Commission as to how that custom related to the facts of the matter briefly, and how then it resolved the issue that you were dealing with?
Thank you, Commissioner. What happens in that particular case? It actually came by way of a review. And I found the accused person is in prison already, has been found guilty of stock theft. The farmer found his clothing, old clothing, dilapidated on the farm where allegedly a certain number of sheep were grazing and they have now been stolen. And that was the only evidence. And he's found guilty of having stolen those sheep. And his explanation is, yes, I did go to the farm, but I went there to collect firewood, which is ukuteza in Zulu, in my own mother tongue. And I went there to collect firewood in order to make fire and cook food. I did not steal any sheep, and that evidence was rejected by the magistrate as nonsense. And looking at the matters, they found that there is no, even if you were to consider this matter on basis of circumstantial evidence, that circumstantial evidence is not enough for a person to be found guilty on that. But most importantly, if his old clothing is found there, and in the ukuteza custom, you use old clothing as a round on your head. We call it in kata so that it is soft when you put the load of firewood on your head, and you go a long distance without fearing the pain in your head. And I found that that person was innocent.
Yes. Thank you. And lastly, Judge, you penned a judgment, the assigned services judgment, when you were acting at the Constitutional Court. I'd like to ask you, how does your interpretation that you gave to Section 198, 3B of the Labor Relations Act, how does your interpretation resolve the confusion that always confronts temporal workers who are hired through brokers, through labor brokers. Thank you.
We would recall that there was a call in the past by various unions that the labor brokers must be done away with because of certain reasons that I need not go to. And the legislature, in its wisdom, did not do away with the labor brokers, but passed various sections, which became sections of the Labor Relations Act, in terms of which it, in fact, regulated how the labor brokers go about in their particular sphere of job. And that particular section, 198, capital A3B, says a person who is presented to an employer by the labor broker, because what happens is this, that the employer simply says, I want 10 people for a particular job. And then the labor broker provides the 10 people from his, in other words, the labor broker remains the employer of those people, and the employer will pay the labor broker the money. And it is the labor broker who will then, from that money, take his own commission and pay a weekly to the laborers. That's how it happened. Then the legislature came with that particular section to say that if one and the same employee has been in the same employment for the period of 6 months, that person ceases to be the employee of the labor broker. That person is deemed to be the employee of the employer directly and must be paid by the employer as if he's an employee that the employer employed directly, not via the labor broker. And in that way, the employee gets security and gets everything. And I think it's a very important kind of judgment that I had the honor to participate in the writing, and I also became very happy. I had a wonderful sleep when fellow judges in the Constitutional Court agreed with me, and I started saying to myself, I'm something.
Thank you, Chief Justice.
Thank you, Commissioner Norman. Commissioner Schmidt.
Thank you, Chief Justice. I'm covered. Thank you.
Thank you, sir. Commissioner Nyambi.
Thank you, CJ. Morning, Judge.
Good morning to you.
My question is in relation to the challenges at the SCA. Any particular personal significant contribution in terms of assisting a person that confided to you about the challenges, even though we have said you have never experienced them personally? Something that you can share with us about the person that came to you about those challenges.
This I hear from the victims, and the victims are talking to permanent judges. It's not easy to take a step as an acting judge. An acting judge, yes, is a judge in terms of the statute, but he is not really a permanent judge such that he can now take steps to address a particular situation. I've done nothing about it, but I feel bad about it. I myself have a passion about acting judges in the division where I come from. I have taken it upon myself to render whatever help they need, and they flow like water towards me, and I've got to go through their judgments. They discuss with me even some complex commercial matters, how they should go about approaching it. I'm not saying they are wasting my time. They actually are growing, because those are the people that will replace us and become permanent judges in the future. If we don't build them, if we do not transfer skill to these people, we are killing the system of the judiciary.
My last question is in relation to the one asked by Commissioner Mpofu, age and maturity. Have you, in your entire life, not come across a young person that is matured?
Well, it's possible. Possible that people can mature earlier, which means it's an orange that sort of got a lot of manure from the soil and grew faster and became matured. It's possible that you can pick up that orange and eat and find that it tastes like a matured orange that has had enough time. It is not impossible at all. But time spent in a work situation makes you grow.
Thank you, CJ.
Thank you, Commissioner Nyambe. Commissioner Nokesi.
Thank you, CJ. Justice Dlodlo, I just have two questions. I mean, there seemed to be a temptation that transformation relates to the geographical spread, the representation into the bench. I would like to know from you, what is your understanding of transformation in relation to the position of the Supreme Court of Appeal? What kind of jurisprudence that must come from that court? And how would you assist in developing the jurisprudence of that court? That's one question. The last one, because you take two. The last one would be, there is a criticism somewhere that our courts have mainly been very strong in terms of socio-economic rights, realization of in that aspect, and the judicial review of executive functions. But insofar as the courts tapping into economic transformation through judgments, there's been little, if nothing has been done. Would you agree with that criticism? And if so, what would you do?
The first one related to transformation. Transformation is a mandatory thing. It needs to be effective. It is both gender and otherwise. It's very important. We cannot have a situation of imbalance. With regard to the SCA, fortunately, the president of the SCA is here. She is better positioned to know how that court stands on transformational grounds. And yes, transformation also requires a guy like Dlodlo. You know, I come from a pure rural area. Simplistic is my characteristic. Humility is my characteristic. We need such people as well, so that the SCA jurisprudence also addresses itself to the customary law, which has had an effect of being overlooked for many times. I have had an opportunity, whilst acting at the Constitutional Court, of expanding on that particular issue in the judgment that I wrote. And it is there, it can be read. But in that judgment also, which is part of the papers, 4C versus the Road Accident Fund, where the mother of a boy who was now working sued the Road Accident Fund because of an accident that took away the life of that boy. That boy was now maintaining the mother. It was not a question of the mother being poor, more than poor, indigent. She had nothing. And the only defense was from the Road Accident Fund. Look, your son had no responsibility to support you. And I, first and foremost, took a point that in traditional setup, and this happens to have been a black plaintiff, no child brought up in a particular home, knowing the backgrounds of that particular home, who now goes to work and gets employment, totally forgets about where he comes from, the roots. And in fact, there is a moral duty in tradition that that child must look after the parents. And I extended the liability towards the Road Accident Fund had to compensate her, and I used traditional aspect of the law. And that it had a disadvantage. There is a tendency of overlooking traditional law. It addresses many ills, and which are not ordinarily existing. We know where it comes from. There used to be commissioners' courts in this country. And those courts were not presided over by qualified people. They were presided over by white people that were taken from various farms. Because they've been staying with black people, it is taken for granted that they know what the black people want. And there was a lot of injustice happening there. And even them, they had an option if the things became a bit difficult for them. They had a mandate in the legislation to apply what used to be called the law of the land and ignore customary law. And there was Section 11 of the Black Administration Act. Fortunately and thankfully, that act no longer exists, which gave the presiding officer an option whether to resolve a dispute between black and black, which is actually customary, by applying customary law or what is called the law of the land. The easiest thing to do for all these presiding officers was to apply the law of the land and disadvantage a practitioner. When you look at the traditional law, you can see clearly that this particular litigant should have won. But because he belongs to this category and he believes in this law system, which is looked down upon, there he is. Injustice has been done.
Sengathi bakuthinta manonini manje. Commissioner Masuku.
Thank you, Chief Justice. Good morning, Justice Dlodlo.
Good morning to you.
I've had the privilege of appearing before you many times, and I served at some point as an acting judge. I sat in your chambers, and what you said about the assistance you give to acting judges is correct. The many challenges that are facing society are ultimately going to require legal resolution. As you would know, there's a lot of social activism. People go on demonstrations, and with the land issue that is coming out, that has always been there, but there's an intensity around the campaigns around that particular issue. The fees must fall and all that. Now I'm concerned about how courts have dealt with those questions where society has sought to assert really what is a constitutional right or a constitutional promise. In the fees must fall, for example. And I'm just wondering what your view would be to recognizing that in certain instances, the courts have to accept the value of this principle called necessity, where an unlawful act is committed by a community because they are trying to indicate to government that, or they are trying to indicate to constitutional functionaries responsible for those, for the provision of certain services, that they don't have them. So, for example, people go on strike, they block roads, they create, problems for the rest of us. And when they're taken to court, that courts ought to recognize that in order for those social circumstances that ought to be addressed to be recognized, it is necessary for them to break the law, as they would put it in some jurisdictions. This principle of necessity, what do you think about it?
Oh, so this is actually a fundamentally difficult matter in the sense that if that violence erupts in a particular community and it affects things like schools and libraries, they are burned down, etc., people get arrested, and the reason why they were decided to resort to protesting in the first place is lost in the stream, And what is concentrated on is malicious injury to property. That library that has been burned down, and which is a crime, which you would agree as an advocate that that's a crime. In this particular instance, courts are somewhat, the hands of the courts are somewhat held together. Legislature can only help in legislating differently in issues like this. I understand what you're talking about. It's a serious challenge, but fortunately we've got legislators and they are some of them part and parcel of this commission, it will eventually be addressed. It's difficult for the court to totally ignore the law, like you have now burned down the library in the course of your protest, and the court can't find otherwise other than the fact that you are guilty of malicious injury to property. It's difficult because that law is quite plain and clear. Your conduct has complied with that law.
Thank you for that response. I had in mind something more, less than burning down libraries and schools, but I accept that there are extremes. The last thing I want to say, it is a loss for Cape Town if you leave Cape Town to the Supreme Court of Appeal, because some of us who practice in Cape Town have found you were an inspiring person for us, young black practitioners in the Western Cape. So that you have now seen it important to mature to the Supreme Court of Appeal is commendable. But as I say, it will be a sad leave for us. And I'm being selfish here because that's how. But I certainly think that the Supreme Court of Appeal would have gained a lot, and maybe the whole country would have gained a lot by your move.
Yeah, well, I can respond by merely saying it would not be a loss to Cape Town, because I have seen a lot of these young practitioners coming to argue cases in the Supreme Court of Appeal. They will see a friendly face that they know, at least even if it is difficult to present this argument, probably that face over there understands me better. And it is just a consequence of life. You cannot be in one and the same place forever. If circumstances dictate that you move, you have to move. If circumstances dictate that you be stationary in a particular sport, you'll have to be stationary. I enjoyed working in Cape Town. I know I may have been tough to the practitioners, but tough to the truth and tough to the law.
Thank you very much, Commissioner Masuku. Has your constitutional court judgment on customary law been handed down now? I don't want to mention the name.
Yes.
I just want to, has it been delivered now? The one on Ubkosi?
Yes.
Okay.
Yes, Chief Justice.
The Mkiza judgment. Why did you not attach it?
At the time I filled in the form, it was delivered a week thereafter, and I felt that attaching a judgment that has not been made public might
look
questionable.
desperate.
Yes.
Okay. And very briefly, if you could, do you get a sense that there is an appetite by judicial officers to protect and develop customary law to the same degree as we seem to have the appetite to protect and develop the common law?
Thank you, Chief Justice. The appetite towards the development of customary law is non-existent. Yes, the appetite in developing common law is alive. And it's a situation that needs to be addressed. People like Dlodlo, coming from the simple community, believing in the effectiveness of customary law, feel that a large majority of people are left out of the system of the administration of justice by the ignoring of this particular system of law, and which is not being developed. But the Constitution mandates us who work with the law to engage actively in the development of customary law. Very soon, certain judges are going to be guilty of dereliction of duty, because this is a very important duty that the Constitution has put on our shoulders.
Thank you very much, Judge Dlodlo, and your excuse, sir.
Thank you very much. Thank you, commissioners.